President and General Counsel of Wisconsin Institute for Law and Liberty. Rick, thanks for being here on Open Record.
Well, thank you for having me.
For our listeners and viewers who aren't familiar with Will, give us a quick background on what is the Wisconsin Institute for Law and Liberty.
Well, we're a legal organization and a think tank, and our mission is to promote the public interest in constitutional government and the rule of law, free markets, and the maintenance of a robust civil society in which we can all seek our own conception of the good.
Before we talk about whether someone should be fired for a distasteful or a hateful social media post, I want to talk about whether they can be fired. What are the limits in terms of what can happen to you if you, and I'm going to say on your personal page, not in a work page, your own personal social media account on Twitter or Instagram or whatever, and you say something distasteful, hateful, objectionable. What are the limits there? Are you protected? What does the First Amendment say?
Distinction between a public employer and a private employer. A public employer will be subject to the First Amendment, but will also have a little greater leeway with respect to how it treats its own employees. If it's something that this individual said in the course of their job, they have almost plenary power to dismiss you, subject to the normal limitations. If it's something that you said privately, the Supreme Court has developed this, I won't say convoluted, but complicated balancing test, which is essentially aimed at getting to whether or not what you said on your private email impairs your ability to do your job for the government. If you work for a private employer, the First Amendment doesn't apply to them. And so they have the ability to discharge you if they don't like what you said, unless it runs afoul of some other legal limitation, such as some provision in anti-discrimination laws, although they typically do not apply to discrimination based on political viewpoint.
I was thinking to myself, I was trying to think the point of absurdity. I know you have to do this sometimes. When you make arguments in court, you have to bring up almost an absurd example and say, well, what about this? So
we call it the parade of horribles.
Okay, so here we go. My colleague here loves candy corn. She is also my supervisor. I do not like candy corn. If I post on social media or I send emails or whatever I do and I say candy corn sucks, and she says, I don't like that opinion, you're fired. Can she do that? If this is a private, employer, can she do that?
Yes, she can. You're an at-will employee, and you can be fired for anything which isn't limited by contract or limited by some other provision in the statute. And there is no protection that I'm aware of in the statute for dislikers of candy corn.
So I lied.
Sorry about
I love
that.
it.
Yeah, okay.
It's great. As long as you have it with peanuts or something. Sure. No, but so in terms of private employment, at-will employment, you're saying there's really almost no limit to what the employer can do. I mean, I know there are. I'm sure employment lawyers would say there are definitely limits. There are things.
There are limits, but the fact that but you don't have free speech is not one of the limitations unless some locality has passed a law suggesting that it should be, and that itself would have a lot of constitutional problems.
So the anti-discrimination factor that you mentioned, so if you were to post something about your faith on your private social media and then your boss fired you for that, then that would be protected under anti-discrimination laws?
Right. Or if somehow what you said could be tied into some form of, racial or gender discrimination, then we're talking about a different situation.
What about, you talked about the distinction between private and public employers. In a lot of cases, we're hearing these are school teachers. They work for a government entity, or maybe it's a city worker or something like that, or a state employee, federal employee. How is it different there?
Let's put aside the situation where, somebody is saying something in the course of performing their duties. Because at that point, you're speaking on behalf of the government, you're speaking on behalf of a school district, and they absolutely can tell you what to say and what not to say, with the exception of universities. Universities are a little bit of a special animal. But let's assume that you're on your private social media account. The question essentially becomes, have you said something which will impair your duty to go ahead and perform your job? And the school teacher is a sensitive position. So I can imagine hypotheticals where a school teacher might say something which calls into question his or her ability to serve all the children of that district. I would have to say that most of the stuff that I've seen on social media, while it may be, and often is, ghoulish, vile, disgusting, inappropriate, it wouldn't fall into that category.
Rick, is there a difference then between if I'm a teacher and I post something about, let's say, this death, and it's that vile, it's that stuff? Is that what's the difference then between that and maybe me going in front of my class and saying, hey, has everybody heard about this? And then giving your opinion?
Well, because at that point, you're acting on behalf of the school district. And, teachers, and I know you're going to talk to a school superintendent later in this podcast who will be able to perhaps articulate this much better than I can. But school districts place all sorts of restrictions and requirements on teachers. You're going to teach math. You're going to use the following textbook. You're going to use, you're going to do the following things. And so at that point, you're really not speaking on your own. You are you are really performing on behalf of the school district, a service for these children, and the school district can direct that. Now, it gets more complicated as you get into a university setting where you have this concept of academic freedom and an open question as to the extent to which academic freedom might be incorporated into the First Amendment in some way, or oftentimes there's a contract which guarantees the right of free speech. But typically in a K-12 public school setting, that you don't have that.
I think you're talking, of course, in government setting, and I know that if maybe there's fewer limits in the private sector, it doesn't really matter. But I think of in many private sector cases, you have employers that now have morality clauses in contracts. Essentially, if you go out and you do something that disparages the company or embarrasses the company or something like that, then we can do something. And I think, as an example, we had a local meteorologist who was fired over posts related to Elon Musk. It was a very controversial situation. People with strong opinions on both sides. And some people I know were saying, but this was on a private account. It wasn't the work account. But that private account identified where this person was employed. And I just wonder, does that matter in terms of sort of brand recognition, or are you representing the employer? If it's your private page, but you say I work here, does that give the employer sort of greater leverage in doing something?
Yeah, right. So to review the fundamentals, the First Amendment applies to the government, doesn't apply to private employers or private entities. However, if a private employer enters into a contract with somebody that guarantees their employment in some way, then the question becomes, well, what does the contract require? And, it would depend on the wording of this morals clause. But if the idea here is that an employee is not supposed to do anything that could reflect poorly on their employer, you're going to have a hard time arguing, well, the fact that this was on my private social media account, or this was something that I did outside of work, if it becomes public and it in fact does reflect poorly on the employer, you're going to have a hard time using that or sort of resisting termination and resisting the use of that morals clause in order to accomplish that termination.